So, mistake number one, choosing the wrong persons to partner with. Mistake number two, I would have to say, is definitely no agreement. So, now you're so busy, you enter the wrong relationships because it's just nobody has time for anybody in the relationship. And now you can't even have the fundamentals in place. If you are going to get into a relationship for intellectual property works to be created with anybody, you must have it in writing in order to avoid these kinds of situations, and even by statute too. Depending on what you're having, especially where you have exclusive agreements, it should be in writing. Otherwise, you're not actually having the transfer of intellectual property happen. So, what should have happened here with the whole screenplay? Two things. Depending on what Omoni Oboli wanted from Jude, she should have had either work for hire agreement, which essentially means that work that Judy Dada is creating belongs to Omoni Oboli's production company. It doesn't belong to Judy Dada. He's simply there, hired for the specific purpose of producing that work, but he understands that he's going to assign all those rights directly to Omoni Oboli's productions company, and that's what it is. This is per Nigerian law, which is also parallel to U.S. law. The second kind of agreement she could have had in place with Judy Dada is a collaboration agreement, which essentially says, hey, I'm the owner of this screenplay. Hey, this is what's going to happen with distribution. Hey, this is what's going to happen with, percentage of how much we own or don't own in the copyrighted work. And the list goes on. Just spelling out the terms in a collaboration agreement on joint ownership and how that parses out and doesn't parse out. She didn't do any of that. And if we believe Jude Idada's account of what happened, he is the one that ended up sending her a contract according to his allegation. And still, she didn't sign anything. But it shouldn't be the screenwriter telling you or pursuing you to sign a contract. You're the filmmaker. You're going to go to an investor and tell them to invest in this. You're going to go to a cinema house and ask them to screen your movie and distribute it and all the other stuff. You have the direct responsibility to get that collaboration agreement in place. Why would anyone invest in such a risk when you can't even protect that intellectual asset to begin with? The onus is completely on you, not even the screenwriter. You should be the one chasing him and begging him to sign something, not the other way around. And that didn't happen in this case by her own statement, because there's nothing in the court record so far that she's submitted that shows that she's chasing him or signing any agreement with him. Once you pick up that phone or email him and say, I need you to stop working and writing on something, and he's doing all those things and he's saying he's emailing you back and forth, even if arguably no actual concrete first draft was submitted to her, just the emails alone about conceptually the things he's writing and the characters and the stuff, that alone is enough to say she had access to this copyrighted infringement work that would ultimately result in her allegedly stealing his whole, the plot, the character, the whole 9 yards.